Hello, welcome to Crime, Lies, and Alibis. My name is Nicole. I know that it's been a while since I've been here. I had been following some other trials and have been kind of irritated because plea deals have been made and I don't necessarily agree with them, but really need to get back in the swing of things. So here I am dealing with, or today we are here for Megan Boswell's sentencing hearing. Now, for those who may not remember, or are not familiar with this case, baby Evelyn had gone missing around December of 2019. And sorry, I'm pulling some stuff up here. She was found guilty. She started lying about the disappearance of her daughter. She had initially said that Evelyn was with her father, Ethan, who ended up not even being Evelyn's father. And I do want to remind any viewers that this is for educational purposes only and seeking justice for victims. Sorry, I'm still looking for things. I just wanted to get on here before everything kicks off and gets started. I'm in finding the channel. Making sure that I can be heard, that I can hear myself. Oops. Go the right direction. My microphone. I'm not even sure that I can be heard. This is great. Let's see. I can barely hear myself. Have it on full. On my phone and see if I can hear it any better. Like I said, it's been a while since I've been here doing this. But I wanted to be able to cover this because I was here since the beginning of her disappearance. Let's try that and see if it's any better. Anyway. So yes, Megan had a little girl named Evelyn. She was 17 when Evelyn was born. And instead of being honest about people and asking for help, she decided that the honest I'm just gonna mute that. So probably edit this out too. So anyway, today is a sentencing hearing for Megan Boswell. She has been found guilty of killing her daughter and hiding her in a shed. And I haven't been here in a while. I've been a little frustrated with things lately, but I'm gonna try and come back and start putting my nose to the grind, if you will, and get some closure on some of these cases and follow some new ones. But for those who are unaware, baby Evelyn had gone missing at the beginning of December. She missed doctor's appointments. There was concerns with her care by a woman who had been babysitting Evelyn while Megan started working at her new job. And instead of asking for help, she either Evelyn died in an accident or Megan ended her life out of frustration. No one really knows because Megan isn't talking. So it could be a combination of some things, but the behavior that Megan exhibited after the death of Evelyn is what's concerning for a lot of people, because she wasn't this mother that seemed to be grieving. She had a new boyfriend. They were taking trips together. They were having vacations to places and going to things like the aquarium, something that a toddler would love. Toddlers love aquariums. We've taken all of our children to aquariums and zoos when they were little. But despite having this child who should have been constantly in tow, Evelyn seemed to have vanished. And every time anyone asked where Evelyn was, Megan would tell them that she was with her father, Ethan, that he was stepping up and wanted to be a dad. And then it turned into Ethan was trying to keep her because he was trying to find Megan unfit to be a mom. And if it wasn't for Tommy, who is Megan's dad, if it wasn't for Tommy insisting and asking questions and wanting to know where Evelyn was, wanting to see his granddaughter, demanding answers from Megan, and then when Megan wasn't giving him the answers that were satisfactory, he took it to police. And he's like, my granddaughter is missing and my daughter is lying. So if it were not for Tommy standing up and being like, I need answers, I need to know, this might not have gotten as far as it did. It ended up getting to the point to where police did start searching everywhere for baby Evelyn. They were looking for in a lot of different areas, combing spaces, and a tip led them to, there's like a compound, they call it a compound. It's all gated and it's owned by Tommy. His house is there, his mother's house is there, and behind his mother's home is a shed that was built for Megan when she was a little girl. And investigators went through that shed and found a kitchen trash can that had baby Evelyn's remains inside. She was wrapped. She was put inside this trash can in such a way that, being they had just gone through cold months as well, she was quite preserved, which is a horrible way to look at it, but she was inside the can, inside trash bags, and there wasn't really a smell until they got to the point where they started unwrapping her. So that's why nobody would have been walking by there. Even if anybody would have been walking by there, they wouldn't have noticed a smell of human decomp because it was all kind of contained inside that garbage can. And they did find her guilty. There are some people in a group that I follow who were there different days for the trial, and one of them said that she was there when the ME was showing photographs of what they found. And for them and for the jury, those images were not redacted. Those images were not concealed for TV. They saw every grisly detail of Evelyn's remains and how she was found. And it was horrifically traumatic for anybody there. So, for people who are on the outside looking in, who never met baby Evelyn, who didn't have the chance to hold her or hear her laugh or her little baby babble, it affected them. It affected strangers, but yet her mother was so seemingly unaffected. And even throughout all the trial, Megan really didn't seem to have a whole lot of emotion. It was just her going through the motions, basically. But there was a moment when her lawyer, Jean Scott, looked at her because, as part of a defendant, it is her responsibility and obligation to sit there and state that she understands her rights, that she knows she has the right to either speak her voice or to remain silent. And silence in the law of the United States cannot be taken as a form of guilt. It is a person's right to not testify. And she was looking up at Mr. Scott, and she just had this smug expression on her face, this little smile, like, nope, I'm not going to testify, and no one can make me. And it was at that moment to where it really pinpointed in my mind and gave me the reality that Megan is kind of narcissistic and very uncaring about what she did, very uncaring about the fact that this little baby depended on her to be her mommy. And instead of doing the right thing and giving Evelyn to someone who would have loved to have taken care of her with all of the options that Megan really did have, she might not have had the best family and had the best support system, but it would have been better off than where Evelyn ended up. And it was just this lack of empathy for the situation and how she treated everything after Evelyn died up until she was found and then court. For me, I really do believe that Megan acted alone. How Evelyn was stored was very immature. The location was very immature. Just no thought process went into it at all. I know that people say that Megan's mom, Angela, or Angel, and her boyfriend William were involved in Evelyn's death. While they may have known that Evelyn was gone, I don't think they were involved. And the reason I think that mainly is because she had cut off her ankle monitor. She was on an ankle monitor, and they cut that off, and she and William fled the state. If they were part of Evelyn's death, would logically, I believe, they would have done a body dump. They would have taken baby Evelyn in any of those stretch of roads between Tennessee and South Carolina, North Carolina, and buried her somewhere there. The fact that she was inside that shed that was close to Megan and belonged to Megan as a child, instead of taken somewhere and properly buried when there was opportunity to do so, tells me they weren't involved in her murder and her death. Now, I know that people are saying, oh, well, William and her mother, Angel, they were given, geez. They were given, oh my Lord, my brain. Immunity. That's the word. The statement is that William and Angel Boswell were given immunity. The thing with that is Angela Boswell. I was right. I think she goes by Angel too. They're really weird because I know Megan goes by Maggie. Like she's had a bunch of different names that people call her, and Angela, she goes by several different names too. But there's somebody who keeps saying that William is who killed baby Evelyn, but because he and Angela were given immunity, that's why he's not in jail. Listen, that's not how immunity works in the United States. A person is given the opportunity for immunity for their testimony. And what that means is if they reveal that they committed crimes during that testimony and they are being honest and truthful, their immunity stands. But if somebody is testifying and they've been given immunity and they lie and they don't tell the truth about their role in the crime, and it is found that they lied, that immunity is void. It's nullified. So this person is claiming that William told them that he killed baby Evelyn, but because he was given immunity, he's not being charged with the crime. Listen, he already has a criminal history. The district attorney is not going to try Megan and Megan alone, a woman who was 18 at the time of her child's death, against a man with an extensive criminal history. They're just not going to do that, especially if he's admitted to killing her. That doesn't make any sense. They're not going to give the guy immunity and him say, oh, well, I'm the one who did it, but I have immunity, you know, charge for murder the one who didn't kill her. That doesn't make any sense. That's not how immunity works. So if someone is telling you, and I'm not a lawyer, if you really have a question about it, go to another lawyer or go to a lawyer and ask them how immunity works, or, you know, a quick Google search will tell you the same thing. Immunity is only granted if during that testimony the truth is being told. It's the same with Jennifer Soto. People are so mad because she was given immunity. And you know what? This was supposed to have started, so why are we on this?
Largest and most trusted job board, connecting you with over 900.
This is so frustrating. They're in the middle of her sentencing hearing and I was on the wrong stinking thing and I wasn't paying attention to the time. Dang it. I have to go back and probably do something. Can I skip this advertisement, crying out loud? I hate this. I was on time. Never had my stuff together, I'm telling you.
In count 2, a jury of your peers having found you guilty of first-degree murder and the perpetration of a felony, it's a judgment of this court you are guilty.
Now for what's tipping the scales in the case of Megan Boswell. She is the Tennessee mom who reported her baby Evelyn, missing, only for the baby to be found dead inside a trash can. Today, Boswell finds out her sentence for the remaining 17 counts that she faces after being convicted back in February. Let's take a look at how we got here.
Evelyn. Hi.
From early December of 2019 until later when her body was found, Evelyn was always in the same place. And Megan Boswell knew that. Megan Boswell knew that because she is the one that put Evelyn there. She placed Evelyn's body in a kitchen trash can.
Did she lie to the police? She absolutely lied to the police. I'm contesting that. It doesn't mean she murdered her child. It doesn't mean she killed her child. What it means is that's her perception that she's going to get in trouble.
Let's get into the last time you saw her. Tell me what that time was like and when that was.
Well, actually, I want to talk about that. I've told TBI where to find her in Mendota. My mom took her to a campground and a silver camper, and if they don't go tonight, I'm going to go find her myself. Because I've told them, and they're not really, like, taking it seriously, and if they don't go tonight, like, I will go myself and go get her.
Tell them why they're not.
Don't get into that.
It's cut.
Stop. Stop. Stop.
No, you need to defend yourself.
That's all they need to know. Quit. Quit.
They already know, Megan.
So, kind of go back into...
Sorry.
No, it's
Sorry.
okay.
Can you edit that?
I said, come high hill water. I said, I'm going to get on the phone. I said, I'm going to find my granddaughter. I said, I don't care what I got to do. I said, I want to know what's going on. I said, enough's enough.
You're telling me all these other stories that you told. All those before, those were lies. This is the truth.
This is the God's truth.
Okay, that timeline, all the dates that you gave, all that stuff prior, all that stuff was made up. And why do you want to come clean down? What benefit do you have?
I don't let you talk to me. To be honest with you.
Is it for me or is it for your baby?
For my baby, but you're the one who were like, hey, like, it's been going on long enough, you know what I'm saying?
And it's time to put an end to it.
A jury of your peers having found you guilty of first-degree murder and the perpetration of a felony. It's a judgment of this court. You are guilty.
So what can we expect today? Will we hear from Boswell? Here to discuss, criminal defense attorneys Joe Tamburino and David Bruno. Gentlemen, thanks so much for sticking around with us this morning.
Oh my gosh,
now, to be clear, the
this is
sentencing today
annoying.
is not for the murder counts, but the other 17 counts that she was charged with.
Okay. Apparently, Court TV is saying that it should be starting any minute. It has not started yet. So that is why we're not seeing what we should be seeing. Coming up, Megan Boswell sentencing. I knew I couldn't have been missing it. I was like, what the heck? I know that I was on the right spot. So it's not me. It's them. I need to go down there and support. I'm on my Facebook group, and this person, I need to go down there and riot anyway, considering the joke amount of child support my baby daddy pays anyway. An ad came on and I got excited. And I'm saying I'm live on YouTube and feeling like an idiot. So, okay, there is a delay. I wonder if she's going to show up with a bow on her head. Let's see what they're saying now. Nothing, just sentencing for Megan Boswell soon.
Evelyn. Hi. My mom took her to a campground and a silver camper, and if they don't go tonight, I'm going to go find her myself.
Megan concocted a story. She told all kinds of different stories depending on the person that she was talking to.
It doesn't mean she's a murderer.
I just want her back. That's all I want.
Tonight. We're live from Denver for CrimeCon 2025. See what special guests join us at the world's biggest true crime event.
Closing arguments live from CrimeCon tonight, 8/7 Central, only on Court TV.
The WNBA is on Ion. The Sky travel to Indy to clash against the Fever. Then the Liberty go coast to coast to take on the Storm. Coverage begins tonight at 7. Find Ion wherever you watch. Ion, it's on.
How prepared is your family if disaster shows up at your doorstep? You can't just turn away a natural disaster. That's why it's important to go to ready.gov/plan before they show up. It has the tools and tips you need to make an emergency plan with your family.
I'm so glad that I'm in the right here because I was getting a little heated thinking I did something wrong. But there is apparently a delay in court. We don't know why. We also don't know why Megan has been moved back and forth several times from prison to prison. We know that after she was convicted, they sent her to one of the women's correctional facilities that is supposed to be her home for the next however many years. But then we saw she was moved back for something. She was supposed to have her sentencing hearing May 22nd of 2025. But I believe that her lawyer was unavailable for that date because he was doing another trial or involved in another trial or another matter. So they had moved court back, and I thought she was supposed to go back in August, but it ended up being September 5th. Okay, here we go. Why isn't it? I'm going to WCYB. Are they there? Because this is the local. I'm pretty positive this is the local channel. Please be it. Come on. I will totally turn on notifications if your stuff works, people. For Pete's sake. Skip ad. Give
15 months.
Okay. What was your role in the investigation?
Of course, as a lead agency, I always stay in contact and communication with all my detectives.
Sullivan County, okay.
Responded to this scene.
Can we make this guy louder?
All the tips across pretty much the region. So, I was constantly in communication with TBI, FBI, and my detectives.
Okay. If you had to give an approximate number, how many Sullivan County employees do you think were tasked with working this investigation?
Aside from my executive staff, which is about 14, we had probably an additional 40 worked around the clock just on this case.
Okay. When you say around the clock, was there 24/7 coverage of this? And are we talking about from the day she was reported missing until the day that she was found?
Yes, ma'am.
So approximately 18 days.
Yeah, from about February 18th to March 6th, I looked through our records, and just overtime hours alone on this case was 740 hours.
Okay. And that's employees working their regular shifts plus overtime?
Plus overtime.
Okay. So, let me ask this first. Did Sullivan County end up requesting the assistance from other agencies?
Yeah, this was a unique case. Normally we work most cases on our own, but we had to pull resources from the Tennessee Bureau of Investigation, the Federal Bureau of Investigation, Virginia State Police, SBI.
What is the SBI?
State Bureau of Investigation, and then we had Tennessee Wildlife Resource Agency, and then multiple local regional jurisdictions up into North Carolina and other states in Middle Tennessee.
Okay. And is that essentially from following tips that were coming in?
Yeah, anything that came through, we followed every lead, try to look into everything that was brought to the VCC, which is the Virtual Command Center through Tennessee Bureau of Investigation.
virtual command center, that's where the tips would come in to decide how to, and send them back out to be investigated?
Yes, ma'am.
Okay. With these different agencies and with Sullivan County, what types of resources were you able to, what did you utilize to try to find this baby?
We utilized every resource that I've ever even been involved in that was at our disposal. I mean, we took jets to different places to expedite the finding of any type of information that may lead to the recovery of Evelyn. We utilized everything the TBI and FBI provided us with, just anything that was at our disposal. And we probably used more resources for this than anything I can ever remember.
We know that one of the stories, false reports that the defendant gave was that a person by the name of Ethan Perry had Evelyn. What did you have to do in regards to following that lead? What resources were used?
Yeah, he was in the military in Louisiana, from what I remember, and we had to send some detectives up there as well.
Okay. And we know another story that she gave was that she kept hinting at Mendota, Virginia, over and over. Is that a lead that you also use resources to follow?
Yeah, United States Marshal, I left that out. United States Marshals helped us out on that one in Mendota.
Okay. She also told you that Angela Boswell, her mother, had Evelyn at some point. Did you follow that lead?
Yes, we worked extensively on that one. We thought that she may have had custody of baby Boswell, so we that went into North Carolina, and I think the dive team went into the ponds over there as well.
Okay. So in preparation for today's hearing, you were asked to review Sullivan County records regarding this investigation, is that right?
Yes, ma'am.
And the records that you reviewed, were they all maintained by the Sheriff's Office?
Yes, ma'am, just the Sullivan County Sheriff's Office.
And the purpose of those was to come up with the manpower that was used?
Yes, ma'am.
To get an approximate amount of manpower and overtime hours, is that right?
Yes, ma'am.
What if the defendant had told the truth on day one?
Yeah.
Objection calls for speculation.
I could ask it in a different way. Would you have found Evelyn if the defendant had told the truth on day one?
Objection calls for speculation.
Sustained. Yeah, you need to reframe it. It's too wrong with it.
If you had known that Evelyn was dead on day one, would that have changed the way you conducted your investigation?
Absolutely.
Okay. Would all of these resources have been used?
No, ma'am.
Were you aware of community involvement during the time of this investigation, the 18 days of investigation?
Yeah, extremely. They really provided us a lot of additional resources that not criminal justice related, just like they brought us food to the office so we could eat and still work, and they all pulled together during that time and just showed tremendous outpouring of support for our entire agency, and across the nation. Really, this was a national recognized case. So the people around here in the community, they started Evelyn's Army, and they provided food for us daily.
Based on your own personal observations, what did the impact on the community look like to you?
Very emotional, just like my staff. I mean, everything you see, people wanted to find this baby, and that was their number one goal. And whatever it may take, whatever it may need, whatever resource may need to be utilized, everybody was willing and able to put in their time, effort, and energy to locate baby Evelyn. And just like my staff, I mean, the emotional toll on them, the lack of sleep, but they never did get fatigued. I tried to send some home, and they said, "No, I'm not going home. I'm going to work on this case until we find the baby."
Okay. No other questions? Please
Thank
answer
you.
any questions Mr. Scott has for you.
I don't have any questions.
Thank you. Thank you.
Stay with call. Take your time, please. testimony about to give you the truth, the whole truth, and nothing but the truth? Yes, sir.
You're Matt Price, is that correct?
Yes, sir.
What is your position at the Sheriff's Department?
I'm Lieutenant in Criminal Investigations.
And Lieutenant Price, you very familiar with the investigation involving the disappearance and death of Evelyn Boswell, is that correct?
Yes, that's correct.
What was your role in the investigation?
This case was assigned to me as the lead investigator with the Sheriff's Office. So I was the lead investigator.
And you worked, the Sheriff has testified to, you worked hand in hand with numerous agencies in the investigation, including TBI, is that correct?
Yes, that's correct.
Okay. And Agent David Gratz at the time, also the two of you worked extensively, that'd be correct. You familiar with the evidence that was collected in the case, the discovery of the body of the victim, Evelyn Boswell?
Yes.
Lieutenant Price, I'm going to hand you some photographs. I'm just going to do this one at a time so for the sake of getting these exhibits in. I'm going to hand you the first photograph, ask you if you can show what's, identify what's shown in that photo.
Yes, this is a photograph of looking inside the playhouse at the trash can where Evan was located.
And is that a true and accurate depiction of,
Yes.
of that scene?
Okay.
Judge, we would move to make that exhibit number 1 to this hearing. Two, I'm sorry. And I don't know if it's helpful, but that was what the trial was introduced as exhibit number 15. I don't know if that's helpful or would create confusion or.
It'll just, it'll be to the point for that sentencing hearing.
Two. You recognize what's shown in the photographs just handed to you?
Yes, I do.
What is that?
Again, this is looking inside the playhouse at the trash can after the one of the bags had been moved off the top.
Okay. Is there anything of significance that you see as you look at the trash can itself?
Yes, it appears that the items inside the trash can have been compressed.
Judge, we would move to make that exhibit 3 to this hearing. Lieutenant Price, would you take a look at the photographs being handed to you and ask if you can identify what's shown?
Yes, this is a picture of the inside the trash can with the blanket removed where you can see baby Evelyn's leg.
Is that the first shot or first, I guess,
Yes.
discovery of the body?
It is correct.
Judge, we would make that exhibit 4 to this hearing. You recognize what's shown in that photograph?
Yes.
What is it?
This is the trash bag that was inside the trash can where baby Evan was located, and also the child is with the aluminum foil and the blanket is laying beside the trash bag.
So the body's been removed from the trash
Correct.
bag?
The body's been removed from the trash bag. It's the trash bag with trash in it. Baby Evan is laying there wrapped in blankets and aluminum foil wrapped around her.
Judge, we would move to make that exhibit 5 to this hearing. Do you recognize
Yes, I do.
And what is that? A picture of?
This is the body of baby Evelyn after she was removed from the trash can, placed inside of a body bag. She's lying there with blankets wrapped around her and aluminum foil wrapped around where her head area was.
Judge, would you make that exhibit 6 to this hearing? Do you recognize the photo that's just been handed to you?
Yes, I do.
What is shown in that photo?
And this is baby Evelyn laying in, still wrapped in blankets, laying on a body bag, with her arm exposed, showing the onesie that she was wearing.
All right. Is that photo, that one of the photos that was taken at the time the body was recovered?
It is correct.
Judge, we move to make that exhibit 7 to this hearing. Lieutenant Cox, do you recognize what's shown in that photo?
Yes, I do.
What is that?
This is baby Evelyn after the blankets and aluminum foil have been removed from her body. It shows the positioning of her head and how she was laying when the blanket was removed.
Judge, we move to make that exhibit 8 to this hearing. Finally, Lieutenant Price, give you one more photo and asking you to identify that photograph, please.
Yes, I can. This is a picture of Evelyn, one of the last known pictures we know that when she was alive.
Judge, we move to make that exhibit number 9 to this hearing. Thank you, Lieutenant Price. If you would answer any questions Mr. Scott has for you.
No questions, Judge.
That's all the evidence is taken.
Judge, Mr. Boswell would like to make an allocution.
I would just like to say that the state of Tennessee treated me very unfair during this whole investigation. And had I had a fair trial and an impartial jury, I would have been acquitted of the murder charges. I would have never hurt my baby, and I did not kill Evelyn. That's all.
No, sir.
I'm sorry. Judge, the state has, prior to this hearing, filed a notice of intent in regards to enhancing factors that we believe apply, as well as a notice of intent to seek consecutive sentencing, which is what we are asking the court to do. And we believe, based upon the seriousness of the offense, as well as the fact that Miss Boswell is a dangerous offender whose behavior indicates little, no regard for human life. And she had no hesitation about committing a crime in which the risk to human life was high. This court should bring those sentences consecutive to each other. And I want to touch briefly on the enhancement factors, and primarily on the one that I think just screams out in this case, which is the violation of trust. Truly, I think the facts that were involved in this case, and the court, of course, consider everything that was presented and that came in at trial, as well as the photographs that have been introduced to the sentencing hearing, which again, those were all part of the trial evidence as well. But the trust that Miss Boswell betrayed upon her daughter was just so callous. She chose herself repeatedly, time and time again, over her child. All deaths are horrible, but for a small child to die in the way that Evelyn died just shows such extreme callousness. And those photographs show you. I mean, she was discarded like a piece of common garbage. Detective Lieutenant Price testified to, it looks like the body has been compressed, pushed down in the trash can, so we can fit more trash, more garbage on top of a child. But probably the most hurtful and severe part of this whole, and painful part of this, is the fact that all that occurred at the hands of the one person that she should have been able to rely upon and trust to protect her own mother. But Megan didn't do that. Megan repeatedly chose Megan. Megan chose her new life. Megan chose living in the big house out by the lake. Megan chose going to the movies. She chose going to Blowing Rock, going to Gatlinburg, again and again and again, over her own daughter. In order for the court to find that the defendant was a dangerous offender and apply consecutive sentencing, there are two things that the case law has said the court has to find. One is that it relates to the severity of the crime. And I can think of nothing that would be any easier than to relate consecutive sentencing to the facts of this case and what Ms. Boswell did. I mean, not only did she murder her own child and then go about her own life, but then once law enforcement was finally brought into the case, not because of her, not because she did anything, but because it finally got reported by her dad, well, then she manipulates law enforcement, it manipulates the community by continuing to lie over and over and over again, causing extraordinary resources to have to be involved for weeks trying to find this child in the hopes that she's alive. And then even after that, even after she finally coughs up the fact that her child is dead, she continues to lie about not knowing where she is. When all along, she's sitting there stuffed upside down in a trash can in her childhood playhouse. So I think it's very easy for this court to find that the severity of this crime and her suffocating her own child, putting her in a trash can, and then repeatedly lying about it to cover it up relates to the severity of the crime. The second finding this court has to make is that it was necessary that consecutive sentencing is necessary to protect the public from further crimes. And provided the court, as well as Mr. Scott, with the case of State v. Taylor, which was a case in which a small child had been beaten to death, and then the mother basically delayed in calling 911, which eventually resulted in the child dying because she didn't receive any medical attention. And the court in that case found that the dangerous offender classification was satisfied because the defendant had demonstrated extreme callousness towards the health and welfare of the victim, and the results were fatal. Well, Judge, I really, it does not get any more callous than what the defendant did in this case. You know, she turned her back, she turned her life, she turned her trust away from her own child. Evelyn got in the way of the life Megan Boswell wanted to live, and so she eliminated that problem. It truly does not get any more callous than that. So the state would submit that both those factors are met and that the court should impose consecutive sentencing. I've already touched on the element as far as trust being involved as an enhancing factor. And then sitting here listening to Ms. Boswell's rather brief allocution, I think it's also right for the court to consider the fact that she sits here today in this courtroom still having absolutely no remorse and taking no responsibility for the death of her child. Once again, she wants to make all of us victims in the case, make herself a victim. Sheriff's office, I guess, should be issuing an apology to her for the way she's just been unfairly treated during this whole process. Judge, Miss Boswell was not treated unfairly. Her child was treated unfairly. Her 15-month-old child never had a chance because of the one person who should have protected her. So for that reason, the state is asking you to maximize her sentence in the remaining counts that she has to be sentenced on, and we would ask that they be run consecutive, Judge. Thank you.
Judge, I guess I'll try to address this in somewhat the way Mr. Harper did, maybe in the backwards fashion. Ms. Boswell had no prior criminal history when this case started, when the investigation started. At some point, she was convicted of a reckless driving B misdemeanor in Washington County, I think in February of 2020. That's the only criminal history she comes to this court with. She's been in jail since she was 18 years old. She will be in jail if this court were to sentence her at the low end of everything, and not run it consecutive. She'll be in jail until she's 69 years old. So the court then has to determine, at that point, is she going to be a threat to society? Society needs to be protected from 69-year-old Megan Boswell. The court should, I guess first the court has to consider the length of the sentence. She's a range 1 offender as to each count. The court should impose I think the sentence is, short of a sentence is as necessary, is what the court is supposed to do to achieve the purposes of sentencing. Here, she's serving a life sentence. She will be eligible for parole at 69 years old. So how much more do you need? Essentially, the state asks you to sentence her to life without parole, is what they want. And we have addressed that issue already in a manner of speaking. We 25 years, not the only jury sentencing I've ever done. But the jury had the opportunity, after hearing all these facts, to consider whether to sentence her to life without parole or life with parole. They sentenced her to life with parole. And I know you're not bound by that on these other counts, but I think in fairness and in deference to that jury, we have to give some respect to what determination they made. And they were aware of all the other charges. Obviously, they heard the guilt phase on those and convicted her of those. So I think that is important to consider that. She's eligible for probation on all the other charges. The court has to make a determination whether or not those sentences should be suspended or served. The court has to make a determination whether, if they are served, how they're served, consecutive or concurrent. As it relates to a dangerous offender who society has to be protected from, I think the case law is quite clear. Not every person convicted of first-degree murder and another felony is going to fall into that category. Normally, in a lot of the cases you see multiple victims, multiple acts. Here, all of those things kind of go together. And I guess the other thing we have to talk about is what counts merged together in this sentence. I would suggest, of course, that the murder counts merged together for one count. That the child abuse and child neglect counts should merge. And that all of the following false reports should merge. Because I sent a case to you yesterday. State versus Smith, 436 Southwest 3rd, 751. This is Supreme Court decided that in 2014. It talks about cases just like this. Each of these cases, these interviews were basically a continuation of the other interviews. And based on the rule of leniency, the court found that even though in that case interviews were made over multiple days with different officers, just in this case that they had to merge. And that's what I think should happen here, is all those counts should merge. And I guess finally I want to address what Mr. Harper said about Ms. Boswell's comments. I think a lot of defendants would probably feel that way. But I think she's entitled to maintain her defense. She doesn't have to come in here for purposes of sentencing and somehow take responsibility. The law doesn't require that. That's not one of the factors to consider for consecutive sentencing. That's not one of the factors to consider for length of sentence. The defendant has a right to maintain their innocence, and to hold that against them and to somehow sentence them to more jail time because they don't come in here and say, I did it. That violates due process. It violates the right to trial by jury, the right to appeal. So I would suggest to the court that the appropriate sentence here should be bottom end of the range. The sentences should run concurrent, and ultimately she should be left with a chance of parole when she's 69 years old, however that is structured.
Court will be in recess for 15 minutes.
Okay, while the court is in recess for the next 15 minutes, I'm going to talk about that moment when Megan took the stand. And her statement was, she did not kill Evelyn and that she was treated unfairly by the state. She said she wasn't given a fair jury. She states that she would have been acquitted if she had a fair trial. Megan is very uncaring And I wonder if I can go back without messing things up to that moment. I don't know if I can do that because it's live. She has this little smile on her face when she takes the stand because, like, this is it. This is her moment to shine. And this is why I have a very difficult time having empathy and compassion for Megan. Because here we hear from the sheriff that he put $5,000 of his own money towards efforts for finding Evelyn, wherein her mother knew where she was the whole time. There were people searching for Evelyn. There were people using resources, and Megan knew where she was the whole time. Megan claiming she didn't get a fair trial is laughable at best. They gave her years to be honest. It's 2025. This happened in 2019 before COVID. She's had 5 years to come clean. She's had 5 years to tell everyone what happened. Instead, she continues to lie. I'm sorry. How do you feel compassion or sympathy for her? I don't care that she's a young girl at this point, a young woman at this point. She is old enough to be honest about what happened and not continuously double down on claiming she is innocent. And now she's claiming that she has been a victim of not getting a fair trial. What wasn't fair about your trial, Megan? You were given opportunity to plead your innocence and prove your innocence. You were given opportunity to tell law enforcement where your child was. You were given opportunity to have a fair counsel. And when you didn't mesh well with one of your lawyers, were given another one. You had the ability to take the stand, something you declined. You had the ability to call witnesses in your defense, and you declined. So I guess I'm confused here on how she thinks that she didn't get a fair trial and didn't have a fair jury. Who did she expect her jurors were going to be? Other young women who had children disappearing and ending up dead? Is that who she thinks the jury of her peers are going to be? When the reality is, it's supposed to be people among her community deciding her fate. They have to be registered voters. They have to live in the county. There is a variation between age and gender and creed, nationality, whatever. I don't understand how she doesn't think she had a fair jury. And I know that this is kind of like a shot in the dark hope that the judge is going to be lenient with her and give her an incredibly reduced sentence. I really hope that Judge Goodwin does not. Because she's not remorseful. Her words are disingenuous. When she says things like she wasn't given a fair trial or a fair jury and she would have been acquitted if she had a fair trial, you know what? This isn't Casey Anthony, which, by the way, Casey Anthony's trial has been one of those things that has plagued the country for decades. Because Casey Anthony got away with murder. She got away with disposing of her child. She got away with committing crimes that she was found guilty for and served next to no time for those crimes that she was found guilty for. But it was 2 decades ago. It was a different state, a different community, people who were feeling sorry for Casey because of claims that were made. What helped Casey's case, and disgustingly enough, the defense was allowed to utilize her father's suicide attempt against him, and in the eyes of the jury, solidified their belief that her dad had more involvement than admitted or whatever. Wow, that is a horrible image. I'm gonna go to something else here, because yikes. We're gonna go to, oh, they're going back to that, thankfully, because, oh, they probably moved it for the jury. No, the jury shouldn't be there, I don't think. maybe. I don't know if the jury's been released yet or not. But just this, it's astonishing to me that she is going to tell people that she would have been acquitted had she had fairness. I don't understand how more fair she thinks she should have gotten. I don't understand how she thinks that she was just targeted for no reason. I don't get it. I didn't kill Evelyn. I was treated unfairly by the state. Wasn't given a fair jury. She would have been acquitted if she had a fair trial. I wouldn't kill my baby. Megan, you did. And I hope that you're in prison for a very long time to think about it. Life in prison, I look at it in two different ways. If Judge Goodwin goes with the jury's suggestion and says that she will have the possibility of parole after 50 years, or like 52 years, Megan could still be alive. But everybody who potentially cared about her or possibly cared about her will be gone. Her parents will be gone. Her siblings may still be alive, but they're not going to want anything to do with her. Oh, mommy is going to be gone. I'd be surprised if that woman lasts another couple of years with the stress that Megan has put her through. That poor woman was dragged into court after she was found guilty to give a witness impact statement and said that she doesn't think Megan did it, and if she could take her home, she would. Oh, mommy is not in a good state of mind. And it was, here's my thing too. What kind of person is Megan to exploit her grandmother, who loves her so much and is willing to come in when her health isn't the best? She can barely walk, is in a very delicate state, and Megan was using her grandmother to get sympathy from the court. It's disgusting. And here's my thing, and I guess it's really a good thing that I am never on a parole board to make decisions for people's fate. But to me, penance goes a long way. If a person is genuinely sorry for what they did, and they're honest about what they did, and they can acknowledge the things that they did wrong, I am much more willing to look at that as, okay, this person's changed. They've seen where they went wrong. And if I were on a parole board, I might be like, okay, well, here are some restrictions or contingencies to your release, and I will grant it. For Megan, I would look at her and say, you cannot be around any minor children, period. Well, if she gets out of prison in 10 years, she's within age to have more children. And if she leaves the state and changes her name, can anyone stop her from doing that? No. I think it's pretty crazy that Casey Anthony never had more children, thank God. But she could have. She could have done it out of spite and not told anyone. Changed her name, changed her appearance, although she had a pretty punchable face, so I don't know how easily she would have gotten away with that. But this case isn't as widely known as Casey Anthony's because Casey Anthony was acquitted. And it was just such a huge talking point during that trial, and so many people were back and forth on this, but there's a lot of people who don't know who Megan Boswell is and don't know about baby Evelyn. So it doesn't have that kind of global, people aren't from all over the world being like, there's Casey Anthony who killed her baby and walked. They know who Casey Anthony is. She's notorious. And she's notorious because she was acquitted. Just like Sorry, my son came in and was asking questions, but there are other cases where people got away with crimes and they've been notorious for that. A global example. But I'm hoping that Megan kind of fades into obscurity, and when people bring it up, they talk about Evelyn and not Megan. But I also hope that Goodwin doesn't give her leniency, because she has no business going out and living a life and living how she wants to live, free, after what she did. And even if she had help killing and disposing of baby Evelyn, ultimately, she's the one holding responsibility here, because she could have been honest about any of it. And she chose to lie. She chose to throw people under the bus. She did it to Ethan. By the way, not only was Ethan not the father of Evelyn, and Megan lied about that, but he was in the military. His grandmother was dying, actively dying, when he was supposed to have had Evelyn. And his grandfather, both of these people who helped to raise Ethan, were saying goodbye to each other after being married for decades. And during that time, when his grandmother was dying, they were being accused of harboring basically a fugitive, because people were believing that Ethan took Evelyn and wouldn't give her back. So instead of these two people, these two lovely people, enjoying the last weeks together before she passed on to the other side, they were involved in accusations. They were involved in having people show up at their door, asking where Evelyn was, calling their home, harassing them, accusing them, and she was dying. And still, Megan wasn't honest. Megan wasn't honest. Then, as soon as it was revealed that Ethan didn't have her because he was on the base, and I think maybe Louisiana, and he never had Evelyn, he never even saw Evelyn beyond a short visit when Megan went to go see him in Texas. He hadn't seen Evelyn since that Texas visit. But once Megan could no longer blame Ethan because he was cleared by law enforcement, then she started blaming her mom. She started blaming other family members. She threw Hunter under the bus. This is not a person who deserves leniency, because she continuously used, over the last 5 years, manipulation, denial, accusations. Hopefully it starts again soon.
Judge, I think General Massey was on her way back. Good, but we approached the
circumstances. The court has considered the evidence presented at the trial at this sentencing hearing. Pre-sentence report filed April 4th, 2025, more than 10 days ago. The principles of sentencing and arguments made as sentencing alternatives, the nature and characteristics of the criminal conduct involved, the evidence and information offered by the parties on mitigating and enhancing factors, any statistical information provided by the administrative officer of the courts as to sentencing practices for similar offenses in Tennessee, located at www.tncourts.gov, and any statement the defendant has made on her own behalf about sentencing and the defendant's potential for rehabilitation or treatment. I'm not sure if it was agreed, but the defendant's a range 1 standard offender under Tennessee felony classification laws. And what that means, the aggravated child abuse and neglect charges are Class A felonies, and as a range 1 offender, those would carry somewhere between 15 and 25 years. The tampering with evidence is a Class C felony. The range would be between 3 and 6 years. False reports are Class D felonies, where with range 1 being 2 to 4 years. The abuse of a corpse is a Class E felony, and failure to report death under suspicious, unusual, or unnatural circumstances, also a Class E felony. Those Class E felonies for range 1 would be a range of 1 to 2 years. In determining where the appropriate sentence should be within that range, while not mandatory any longer, the enhancement factors and the mitigating factors are advisory for the court. The state has urged in its filing state's urged number 3, enhancement factor 3, that the offense involves more than one victim. I think for purposes of this case and all the proof that I heard, I can understand how that argument could be made, but I'm not going to find that enhancement factor number 3 applies. Enhancing factor number 4 is urged by the state. A victim of the offense was particularly vulnerable because of age, physical or mental disability. I think that will apply. Testimony was that baby Evelyn was, everybody keeps saying 15 months old. I think she was 15 months old when she was found. My recollection of proof was that she was approximately 13 months old when she went missing. Is that wrong?
She was, her approximate age at death was 15 months old.
At death?
At death.
Okay. So she was 15 months old.
It was 13 months old at death. It was 15 months old, they assumed, when she was reported. When they didn't know she was alive or dead.
So at the time of her death, she was somewhere between 13 and 15.
Yes.
The state, the court accepts enhancing factor number 4. Number 5 was urged by the state. The defendant treated or allowed a victim to be treated with exceptional cruelty during the commission of the offense. I don't know, and I'm not going to sit here all day and regurgitate the facts from the 11-day trial. But thinking back on the proof that I heard, there can be no more cruel act than to stuff a 13 to 15-month-old baby wrapped in blankets and aluminum foil head first into the trash can. Especially when that 13 to 15-month-old baby is your baby. So the court accepts number 5. Number 6, the personal injuries inflicted upon or amount of damage to the property was particularly great. The court accepts number 6. There's no greater injury that you can inflict on another human being than death. Enhancing factor 10 was in the filing. Defendant had no hesitation about committing a crime when the risk of human life was high. The court accepts number 10. And then 14, the defendant abused a position of private trust. And again, the relationship between mother and child, there can be no greater private trust on this earth than that. So the court accepts number 14. Those are all the enhancing factors that were urged, all the ones that the court, after having looked through them, believes applies. Next, I have to consider mitigating factors in determining the appropriate length of sentence. And again, I'm not going to read, there's 12 statutory mitigators under 40, 35, 113. I'm not going to read all of these in. The defense didn't put any arguments forward as to any mitigating factors that should apply. The court, though, is required on its own, after having read the pre-sentence report, heard the proof, to apply any factors I think are applicable. So there's at least one that could be applicable, and I'm going to talk about it for a moment. If the defendant, because of youth or old age, lacks substantial judgment in committing the offense, the proof is that she was 18 when the killing occurred. But I also have to look at, so there's no question that she was a young adult. But I also have to look at all the other proof and circumstances surrounding the case. And it became very clear to the court upon hearing the evidence that the defendant, in her mind, saw a chance to lead a different life than what she thought she was going to be leading. And quite frankly, circumstantially from all the proof, baby Evelyn was a stumbling block to leading that life. So she made the decision to remove that stumbling block. And because that's the tenor of the proof that this court heard, I reject mitigating factor number 6. She exercised judgment. It wasn't good judgment, but she exercised judgment in doing the things that she did. So of the 12 statutory mitigators, the court doesn't find that any are applicable to this case. The 13th is any other factor consistent with the purposes of the chapter. And courts regularly, if a person comes to the court without a substantial criminal history, courts regularly include that as factor number 13. If a person comes before the court and they've had a long, productive work history, then that factors into 13. If they've had military service, those are the kinds of things that factor into 13. In this case, Ms. Boswell, she did not have a long work history. In fact, the pre-sentence report said, she stated that she'd only ever had one job in her life, and that was at the chicken shack where she was working right around the time of this killing. I am going to give her credit for not having, even though she was only 18, I'm going to give her credit for not having a substantial criminal history, either as an adult or a juvenile. So, the court weighs all the facts that I've heard during the trial, all of the testimony that we've heard at this sentencing hearing. When the court weighs the enhancing factors and the mitigating factors, that's how I arrive at a verdict, or not a verdict, but a sentence. I do want to talk, and I'm going to talk about each of these counts individually with regard to the enhancing factors. Because if an enhancing factor is part and parcel of a charge, then it can't be used as an enhancing factor. So for count 4, aggravated child abuse, the state has to prove that the defendant knowingly, by other than accidental means, treated a child under 8 years of age in such a manner as to inflict serious bodily injury. The court is of the opinion that number 4 still applies because of the tender age of the child at the time. It's one thing to be a child under 8 when you're 6 years old or 7 years old. It's quite another thing to be vulnerable because your age is still literally being counted in months. So the court finds number 4 applies. Number 5 is not an element, it applies. Number 6 applies due to the death is not an element of aggravated child abuse or aggravated child neglect. 10 and 14 apply. So the court finds that they all apply. Counts 4 and 5. So the court's of the opinion in that Class A felony that the enhancing factors and the aggravated nature of this case in general take that sentence from 15 to 25 years. And when the court weighs, and quite frankly, each of these enhancing factors, with the exception, number 4 has low weight because of its similarity for those 2 counts, to the charge. 5, 6, 10, and 14 have great weight. The court affords very little weight for the fact that Ms. Boswell, at 18 years of age, had no serious criminal history. So the court's of the opinion in counts 4 and 5 that the sentence should be 25 years. court's also of the opinion that count 5 merges into count 4. In the tampering with evidence, the court's of the opinion that all the enhancing factors should be afforded great weight, and the sentence should be 6 years. The mitigating factor, which is the court's been giving very little weight, would not bring it back down. Now, with the false report, the court's of the opinion that the enhancing factors would take that sentence from 2 up to 4 years. And again, there being only the one consideration of the mitigator, it'll be 4 years. Under the case of State versus Smith, Tennessee Supreme Court, 436 Southwest 3rd, 751, handed down in 2014. Justice Holder, I believe, delivered the opinion of the court. And the opinion of the court was that due to the principle of lenity, not leniency, that a false report, because the legislature was ambiguous as to how they think that a false report should be punished, that the unit of prosecution isn't determined by the number of individual and distinct occurrences of false statement, but that the unit of prosecution is whether a false statement was given pursuant to a particular incident or offense. At least that's the way I read it. So it wasn't that it's a continuation of the interview. It's that the incident that is in the officer's concern is the disappearance of the child. And the Supreme Court says in that case that even if you tell 16 false statements about the disappearance of that child on different days and to different people and different variations of the story, it's still one incident. It's the disappearance of the child. So counts 7 through 17 all merge into one count. So they all merge. Counts 8 through 17 merge into count 7. In count 19, the courts of the opinion the enhancing factors take that sentence from 1 up to 2 years. So that'll be a 2-year sentence. In count 20, and again, I'm weighing the lack of mitigators. In count 20, that sentence will be 2 years as well, for the same reason. Now, since I've already talked about merger, the courts of the opinion that counts 1, 2, and 3 would all merge into a single life sentence. So counts 2 and 3 merge into count 1. Now we'll talk about consecutive sentencing. In the state's filing, the state under 40, 35, 115 urged, and I think this might be a mistake, but urged number 2, that the defendant is an offender whose record of criminal activity is extensive.
And that's the court's ruling. I just so clarify, it wasn't a mistake, but at the time it was filed, when we would have all the false report counts, a lot of false criminal history, obviously since the court started.
court rejects it. But the court also relies on enhancer number 4 from the same statute, 4035-115, that the defendant is a dangerous offender whose behavior indicates little or no regard for human life and no hesitation about committing a crime in which the risk to human life is high. Now that's what the factor says in the statute. But it's pointed out in State v. Taylor, (2017) Westlaw 2179952, also case numbers M 2015-02142-CCA-R3-CD. It's an unpublished case, but the unpublished case references published opinions. And the most important one that it references is State versus Moore, that quotes from the main case is the Wilkerson case, 905 Southwest 2nd, 933, Tennessee Supreme Court from 1995. And the Supreme Court, in determining the appropriateness of 4035-115 enhancing factor number 4, states that in addition to what's stated in the statute, that a court must also find that a consecutive sentencing is necessary in order to protect the public from further misconduct by the defendant, and that the terms are reasonably related to the severity of the offense. So, from the facts of this case, and again, I'm not going to just keep repeating it. Everybody who sat through that trial knows the facts that came in. The testimony during the trial was that that child was suffocated. When you look at the pictures of how tightly this baby was wrapped in blankets and aluminum foil, and the mechanism of being stuffed into that trash can head first, there's no doubt in my mind that this defendant had absolutely no hesitation when she killed her daughter. And in hearing the proof during trial of how she continued to live her life, and from hearing the proof circumstantially as to why she might have done this deed, because this new boyfriend is the life that she wanted to grasp onto. It's like the state said, the house on the lake. A lifestyle that she wanted for herself. The the fact that Evelyn was just in the way. And looking at all the video that we saw during the trial, this court never once saw remorse, never once saw empathy out of the defendant. So she is a dangerous offender. The circumstances surrounding the commission of this offense are absolutely aggravating. This baby couldn't care for herself. This baby had the only life this baby knew. The only way this baby could get through a day was through her mom. And I understand that the way the parole system is set up when dealing with a life conviction is that she has to serve 51 years before she's even eligible for consideration for release. And Mr. Scott asked the question during his argument, which was the right question to ask. Is Megan Boswell at 69 years of age coming out of prison a risk to society? And the only conclusion that I can come to after hearing the proof in this case, seeing the evidence in this case, seeing how utterly unconcerned with the fact that she took the life of a 15-month-old child, her own child. The court has to answer that question, yes. That society does need to be protected from the evil that lurks in her heart. And then would the aggregate length of the sentence reasonably relate to the offense which she stands convicted? For the same reasons I just said, yes is the answer. So the court finds that all those sub-factors, if you will, are met. And I want to read a passage. And I think the state may have, but I highlighted this yesterday when I read the case. In State versus Durantes, 331 Southwest 3rd, 370, at page 376, the Tennessee Supreme Court in 2001 found that the dangerous offender classification was satisfied where a defendant demonstrated extreme callousness toward the health and welfare of the child victim, and that the results of that callousness were fatal. It's almost as though that passage was written to describe this case. Therefore, the 25-year sentence for the merging counts of aggravated child abuse and neglect will be consecutive to the life sentence. The 6-year sentence for tampering with evidence and the 4-year sentence for false report will be concurrent with each other, but consecutive to the 25 years. And the 2-year sentences for the abuse of corpse and not count 19 and count 20 will be concurrent with each other, but consecutive to the 6 years. So in counts 4 through 20, that'll be a 33-year sentence as a range 1 standard offender, consecutive to her life sentence. The court has considered probation. She's not eligible for probation on the Class A felonies. That 25 years has to be served by statute. The court has considered probation on the additional 8 years and finds that a grant of probation would depreciate the seriousness of this case, given the facts of this case, given the fact that she has shown no remorse, she has shown no empathy towards this child, her child, and probation in those counts will be denied. Mr. Scott, I believe at sidebar you had indicated that you would like to have a transcript prepared before, in order to prepare the motion for new trial.
Yes, Judge.
I'll order that transcript, whatever order I need to sign, share.
Judge, I would also like to have this sentencing hearing as well.
Sentencing hearing will need to be typed up as well. We'll set this for status. We'll send Ms. Boswell back to TDOC. And let's set this for a status on January 16th to see where we are on getting the transcript prepared.
That's fine, but I'll wait Ms. Boswell's appearance at that.
Well, what I'd prefer her to do is appear by Zoom.
That's
If,
fine.
if she can, but if not, yes, we'll we can wait.
Okay.
All right. All right, that's all.
So if I'm understanding correctly, she just got life with an additional 33 years? I'm confused. And I know that I'm going to have to go back through and rewatch this. I had closed captioning on, but it wasn't working. So I'm probably going to have to come back and do another video on this. But he found that she was just not remorseful, that she didn't, I don't know.
You're gonna want to hear this. I want to feel things.
I'm trying to find skip ad. Let's see what I can find before I have to go and come back to this later. So, Megan Boswell sentencing. So she was given 84 years. So in 84 years, she'll be eligible for parole. And the reasoning behind this decision was just disingenuous, uncaring, has no regard for the things that she did, has no sympathy for the life that she threw away, because that's what she did. She threw her life away. And I mean, she had the chance to plead to the court and say that she was sorry. She had the chance to come clean and say, hey, I've been found guilty. Please have leniency on me. I'm sorry. And whatever. Instead, she gave her little smirk and her fake tears that are only for herself because she knows her life is over. She's cooked. She's not getting out of prison anytime soon. This is her life now. And said, I didn't get a fair trial. If I had a fair jury, I would have been acquitted. Like, if that is not a slap in the face to this judge and the court and the jury and to the district attorney's office and to her legal this is Megan's problem, is that nothing anyone else does is good enough. She's the victim here, not Evelyn. Evelyn's not the victim. She's not saying, hey, the real person who killed my daughter is out there. They're not even trying to find them. They're not even trying to hold them accountable. None of that. She's doubling down that she didn't do anything to her daughter and that it wasn't fair. Her trial wasn't fair. She wasn't treated fairly. This is what she's continuing to say. It's me, poor me. This isn't fair. I wouldn't hurt my baby, but gives nothing as to an answer or any kind of inclination as what could possibly have happened that she was not in control of. She didn't even say Evelyn died. It was accidental. I gave her something because I needed her to sleep and she wasn't going to sleep. And I think I gave her too much and that's how she died. None of that. None of that. We don't get any of that from Megan. We don't get that it was an accident. We don't get that it was intentional. We don't get that anyone else was involved that she can, verify with any kind of evidence or proof. None of that. And in the last moment before sentencing, when she could have said anything to plead to Judge Goodwin to give her a chance, to be kind to her, she doubled down and said she didn't get a fair trial. Good. I'm glad she got 84 years. Because I don't care if she was about 18 when it happened. She's not 18 anymore. It's been 5 years. She's had 5 years to accept her role in Evelyn's death. And still, she's the victim. Judge Goodwin did a very good thing today, and I know that it had to have been hard. I have a lot of empathy and respect for everybody who is part of this investigation and part of this trial, and I want to thank you from the bottom of my heart for seeing justice for baby Evelyn. I know that there are children out there who don't get this kind of justice, but maybe Megan can be the new standard, the new message to people. Don't do what Megan Boswell did. Because Casey Anthony might have gotten away with it, but Megan didn't. She's going to spend the next 84 years of her life, which, let's be real, she probably won't be alive that long. 84 years is a very long time. 84 years is a long time for a newborn, much less for Megan. But you know what that means? By the time she is eligible to leave that prison, baby Evelyn would have lived an entire lifetime. Thank you for listening. Stay tuned for more.